Hello and welcome to CPR's YouTube channel. I'm Russ Bleemer, CPR's editor for the monthly newsletter Alternatives to the High Cost of Litigation, which can be found at altnewsletter.com. And I'm joined once again by Professor Angela Downs. She's at the University of North Texas in Dallas, the College of Law there. She's a professor of practice and assistant director of experiential education. And also in Dallas, we're joined by attorney, arbitrator, mediator, litigator formerly, Richard Faulkner. I'm in New York with Philip J. Lurie Jr. of the Lurie Law Firm. He focuses on arbitration and litigation surrounding arbitration. And we're reconvening this group again because the U.S. Supreme Court recently agreed to hear its second case on arbitration for the 2023-2024 term. We digested it and wanted to talk about it here. Now, we've already discussed the previous case, Bissonnette. It's here on CPR's YouTube channel right below. And now we're going to look at the new case, Coinbase versus Susky. Indeed, it's a case that was dismissed in June as improvidently granted in the court's most recent arbitration decision. This case has been before the court before. The new Susky case was dismissed in that June opinion in a case called Coinbase versus Bielski. Coinbase versus Susky and Coinbase versus Bielski, back in the June opinion, were consolidated cases. The ultimate holding in the Bielski case, after dismissing Susky, was that stays of litigation are mandatory while a party is appealing a determination against compelling arbitration. Susky's different, and its path back actually, weirdly, isn't unprecedented. In 2020, the court also dismissed the case after it had been argued on a very similar issue. The issue was whether incorporating rules was enough to indicate the intent of the contracting parties to arbitrate. And as an interesting precedent, that case, the Shine case, had been decided and returned to the court, similar to Susky. As is usual in our alternative dispute resolution arbitration area, that's a lot of names and a lot of train spotting. So here's the real takeaway on this. These cases are on just about the same question, or at least close enough. They're descendants of one addressed and decided by the court in 1967 in the Prima Pate case. It's a question of who decides whether a case is arbitrated. Is it the decision maker, the court, or the arbitrator? The basic rule, if it's a problem with the contract, then the parties agreed to arbitrate will go to the arbitrator. If the problem is about the specific arbitration clause, then that's going to go to a court. Now, of course, you can make it much simpler and indicate what you want and how you want it in the contract. But after years of our expert panel here nagging people to draft better arbitration clauses in anticipation of arbitration, this issue keeps coming back. The blame is probably on the SCOTUS case of Rent-A-Center versus Jackson. It's a nearly 14-year-old decision that looked at the agreement to arbitrate enforceability, okay? Prima Paint evolved into Rent-A-Center and produced sophisticated versions of these arbitration agreements, or better termed arbitrability provisions. But again, the clarity here isn't always the defining feature of these who decides clauses, and that's how we wind up where we are today. The Rent-A-Center gloss on this agreement to arbitrate the enforceability of arbitration was dubbed in the Rent-A-Center case the delegation provision. Here, in Susky, this delegation provision sends customers of the nation's biggest cryptocurrency platform to arbitration and their agreements to sell cryptocurrency on the Coinbase platform. But then these customers also signed up for a sweepstakes, which has a whole nother set of rules. Those rules fell into dispute. So does the original agreement's delegation provision, again, the agreement to have an arbitrator decide whether an arbitration agreement is enforceable, does the original customer agreement at Coinbase delegation provision apply here? There isn't one in the accompanying new sweepstakes contract, which does have a choice of forum clause talking about California courts. Coinbase here says the delegation provision does apply. The agreements are integrated and the case should be arbitrated. David Susky does not want to arbitrate and says no, and the Ninth Circuit Federal Appeals Court agreed. The Supreme Court, 7 days ahead of this recording, agreed to hear it. There are two different contracts here for these customer contestants. So which one rules and why? Phil Lurie, welcome back. What do you think?
All right. It's a very interesting question, and it's a very kind of specific question that the Supreme Court has agreed to hear here. It's really to me, is the application of the clear and unmistakable rule that's required for arbitrating agreements to arbitrate arbitrability. And I think, as we'll see in just a sec, that there's another issue lurking here, and that is, to what extent does this case implicate the federal policy in favor of arbitration, as that policy has been narrowed and redefined by Granite Rock, and also by more recently Morgan versus Sundance. And that may be what this actually all comes to turn on. But to understand that, let's take a look at the arguments and how it might be decided. Now, the first approach is the approach that the petitioner is arguing, and I call that the ring fence approach. And I call it the ring fence approach because under the doctrine of severability, you're supposed to treat these delegation provisions as having a separate existence from not only the arbitration agreement, but the contract itself. And the way the ring fence argument works is that not only are they separate, but you say that they're basically immune to attack based on the existence of any other evidence of the parties' intent to arbitrate arbitrability. So that's an approach which, by the way, I endorsed in an alternatives article when I first talked about Shine 2. But I have to say, after seeing what happened with the Shine 2 case and oral argument, and having discussed it in many other occasions, that case, that argument doesn't necessarily work, and it certainly doesn't work in this situation where what you're trying to ring fence away is an entirely separate contract, which not only doesn't contain an arbitration agreement or mention delegation, it expressly says that that California courts, state or federal, have exclusive jurisdiction over any disputes concerning the sweepstakes. And
Coinbase's argument there is kind of, we didn't really mean what we said in that contract. It's really the other contract.
Well, yeah. Well, now I'm going to get to that because and we'll look at that in just a sec. But their argument is, it's ring fenced, and it doesn't matter that there was a second contract because we agreed to this delegation provision. As Rick had mentioned before we got started here, one of the dangers of this case is that if these arguments were to be accepted, that you once you entered into a delegation agreement, you're basically, that's it. There's not really much you can do to make it go away. I mean, how would you rescind it? But so I don't think the court's going to buy the ring fence approach in this case. I think what you need to do here is say to yourself, there are three ways of looking at the party's intent to arbitrate arbitrability. One is, as we said, the ring fence approach, but the second, though, is solely from the standpoint of the official rules. So let's pretend that's the only contract. Well, if that's the only contract, then there's absolutely no question that the parties did not agree to arbitrate any disputes about this later agreement, let alone any disputes about the arbitrability of arbitrability. And so you have that. Now, if you the third way of looking at it is that, well, let's look at both agreements. Let's put ourselves in a position of looking at it from the standpoint of both agreements. Well, if you do that, what you come up with is the parties. If you look at only the first agreement, well, okay, you can say that they clearly and unmistakably agreed to arbitrate disputes. But if you look at concerning arbitrability, but if you look at the second agreement, you say, well, they haven't. So if you put those together, you have a hopeless conflict on arbitrability of arbitrability, and that means that the clear and unmistakable rule has been violated, and that that there is no delegation agreement concerning this dispute that is enforceable. But that's one way to decide it. And there's an independent reason, as I hinted at before, and that has to do with federal policy on arbitration, how it's been limited by Morgan and Granite Rock, and basically Morgan said is that that policy is merely an acknowledgement of the FAA's commitment to overrule the judiciary's long-standing refusal to enforce agreements to arbitrate and place such agreements upon the same footing as other contracts. The federal policy about treating arbitration contracts like all others, that's what it's about. It's not about fostering arbitration. So what the ring fence approach, I think, creates a sort of Uber contract, right? It's treated in a way that no other contract would be treated. But I think what should be done here is that you got to look at both contracts and then ask yourself, well, was there a clear and unmistakable agreement by the parties to arbitrate arbitrability issues that concern the second agreement?
On the ring fence approach, I mean, I may be a party of one here, Phil, but you work in insurance a lot. It struck me that the argument was like reading insurance policies where you have an umbrella policy and then you have your subsidiary, not riders, but subsidiary policies that come under it. I have an umbrella policy for general liability and have auto, and I have home personal and a jewelry smaller policy, not a rider. That seemed to me the argument they're making, although it's not in any of the papers. It seems analogous to like an insurance umbrella policy.
Well, I'll tell you how it differs, because what you're talking about, you have this in reinsurance and insurance, is the structure of coverage and the interrelationships between policies. And in those situations, every one of the subsidiary policies is generally consistent, certainly in terms of limits and trigger and issues like that. Yeah. So you hope. Well, that's right. And when there's not, well, guess what? You got a big dispute and there's a problem. So I don't know that is going to help them that much, because here it's like if you had two different policies, one that clearly covered the dispute and one that clearly did not, and then you're trying to stack one on top of the other, and it doesn't work. But so there's that.
Rick or Angela, do you want to point out? Let someone else jump in, Phil, on which one of your approaches they think that the court might take.
Well, I'll hop in here because two things. One, like Phil, I do quite a bit of work with insurance, and I arbitrate insurance, reinsurance coverage disputes, have done for decades. But quite often nobody matches these policies up. And as Phil kind of, alluded earlier, I've been a special master for the federal court in Texas trying to unravel the mess that had been hanging around since 1987. The cases were over 20 years old, trying to figure that mess out. We did. I got it resolved. But let's go to this case, because we're going right back to, I guess, the gift that keeps on giving to myself, Rent-A-Center v. Jackson. And when I drafted the language that was ultimately approved by the Supreme Court in that case, I had a specific point. That language is also far, far, far more specific and clear than anything in this case or any of the other delegation clause cases, because much of what I drafted uses very stilted language that comes from my French background. And that's why you see terms in Rent-A-Center that, like void and voidable, things that if you understand true civil law have specific meanings, and it's very detailed. And that may be a way out for the court in this case, to say that if in fact unsophisticated parties, like the gentleman here, intent consistent with Kaplan's clear and unmistakable standard to agree to delegate arbitrability, then they should do so in very, very clear, understandable, uncontradictable language, which wasn't done here. The AAA and JAMS have both put in place provisions that basically say, and I think AAA Rule 7, the arbitrator shall have the authority to determine jurisdiction. And we've talked about that before in other cases. That is nowhere near the type of full-page arbitration and arbitrability delegation provision that actually existed in Rent-A-Center. Hugely different language. And, you know, what Coinbase is trying to say in this case here is that effectively, once you have a delegation clause, it's, you know, Hotel California or a Roach Hotel. You can come in, but you can never leave. And that's ridiculous.
You know, but Rick,
And, you know,
but Rick, pull
these
it,
are zombie clauses. How do you
pull it.
kill the zombie?
Yeah.
And maybe these parties have properly done that by saying the California courts would have exclusive jurisdiction of the issues in the sweepstakes case. But one of the things that hasn't been hit here is, well, what happens if you do, in fact, delegate to the arbitrator? Because then that arbitrator has a financial self-interest in the outcome of that determination. And that, I see Phil going there. Yes. And let's face it, I know Phil and I have seen cases where the arbitrator's fees exceeded $1 million. That is a lot of incentive to always find arbitrability. And giving those issues to an arbitrator who is still allowed to sit on the remainder of the case is a huge problem. It's only one step removed if, as in City Beverages versus Monster, you know, the person is an owner of an entity, an ADR entity, but I don't think that gets the AAA out of the situation where they say we're a nonprofit, because there's still an interest in having business come in. So I think it really logically and ethically should have to go to the courts to make these determinations, because otherwise the boilerplate that almost all of us have used, me for a lot more decades than the rest of y'all, with arbitration, assignability, etc., means these clauses are going to be hanging around, forcing people to arbitrate things, perhaps with entities they never agreed to in infinite arbitration clauses for 40 or 50 years.
I want to pass it. I want to pass that over to Angela. But I just, to sum, we've been doing these YouTubes now for 7 or so years. And
Yes.
when we talked about Monster Energy back in 2019, whenever the delegation provision comes up, we're reminded that Phil had proposed the idea of an independent panel
Yes.
to determine arbitrability. It adds another layer, but we all kind of agreed that sort of makes it fairer in the determination and a little less self-interested. Angela, I don't want to put
that language, by the way, back about 20 years ago. It actually was in the first agreement that became Rent-A-Center.
Yeah, I think that was Rick's idea.
Angela, you've talked a lot about, I don't want to put you on the spot, you've talked a lot about the need for precise drafting in here. One big takeaway from all this is it was right there in Justice Scalia's opinion in 2010 in Rent-A-Center on drafting and the need for precision drafting and the need to deal with arbitrability. Has the legal profession, we keep seeing this come up over and over again, have they just not heard you saying you've got to draft better?
Definitely have not heard me, but I will keep ringing the bell with that. And I think with what I'm calling Coinbase Part 2, you know, in the nod to Rick's French heritage there, you know, the issue with this case is that no court has really asked or answered the question that Coinbase has. And a lot of legal scholars are saying that the question itself is flawed. And so I think that is part of the issue that we're dealing with. And, you know, the question that they're asking of whether an arbitration agreement with a delegation clause always requires an arbitrator to decide whether a larger contract is modified. No court has answered that. No court has answered that question. It's a broad sweeping question. And what is already established is that even if there were a clear split in authority, which there is not, it would not be a split over the question that Coinbase presents. So the question that Coinbase is putting forth is something that is not, it's a non-issue. And there's a reason that the courts have not addressed the question that Coinbase asks. My opinion is the reason is that that question of law has been settled.
Absolutely.
You know, the court has consistently held that parties can delegate that threshold arbitrability questions to an arbitrator, so long as the parties' agreement does so by clear and unmistakable evidence. That's in several cases that we've talked about before, the Shine case.
Rick had just noticed it comes
Yeah.
from first options is where the
First
language.
option.
Right.
It actually goes back to AT&T
Yes.
technologies. Yeah.
Yeah. So it's, the clear and unmistakable requirement, it's an interpretive rule of contract law. So it's established and it pertains to parties, their intent, as we're looking at their manifestation of intent. And I think that was from Renner Center. So it's something that's already established. So, if the court tries to answer their broad question, it would make the parties' intentions for those contracts to be formed after the delegation agreement would be irrelevant. So
Well, this coming out of California, there's yet another bit of fun. Not only, as Russ talked about, has the California legislature attempted to specifically reverse the prior U.S. Supreme Court decision, but California also recently passed a right to delete statute. So, this is a zombie clause, and I picked that up from our colleague, Professor Solly, which is, okay, this is a clause in a contract of a preceding time. California's new right to delete clause provision is going to require a single place where any California citizen can go to a business or a data broker and say, delete every agreement, every bit of information you have about me. Is that going to eliminate that prior contract from a year or 5 years or 10 years or 15 years, as we've seen in other cases where AT&T, amongst others, tried to assert that an agreement to arbitrate with AT&T was then applicable to Singular after it acquired Singular about 15 years later.
Rick, how broad is the delete? How broad is the new delete law? Is it just focused, I assume, on arbitration provisions? It's broader than delegation.
No, it's not focused on arbitration. It's delete information held by data brokers.
What's the look back on that, Rick?
Yeah. It's not clear, y'all. This is the California.
Yeah, because
forever.
And I think a lot of we have these policies and legislative efforts that come down the pike where it sounds like a great idea at the time, but it's kind of the devil's in the details. Yes. And it's the application that of what gets us. What's going to be the mechanism to get this out to consumers so that they know that it's available?
Specifies a mechanism, and all data brokers have to register starting, I think, in January 2024, and then 1 year later they must have a single point of reference for California consumers to go in and demand and enforce the demand to delete the data that is being sent. So I'm looking at this from the boilerplate assignability provision of can the original live entity assign to something that becomes a zombie and have that enforced down the road? This is going to be one heck of a mess.
Yeah, it is.
And
it goes back to the point that Russ had, the question that he posed to me was, we need to get this correct on the front end.
Exactly.
The language needs to be clear and consistent so that consumers understand what's happening and their rights.
Yeah.
Well, the FTC has been going after dark patterns and has filed a number of lawsuits over that. They've recently sued another data broker that I just saw the lawsuit was unsealed, I think, on Monday. And, these are becoming very hot, contested, hotly litigated areas. And anytime you have the federal government present by the Federal Trade Commission and other entities suing other business organizations over some of their standard provisions and activities, these are things that people need to think about up front.
Yeah,
and maybe absolutely. What we need is a clause that says, hey, I consent to arbitration, but only and exclusively in this contract and no others, a month, a year, a decade, a century from now.
Yeah, it turns into an infinite arbitration clause.
Exactly.
Issue.
Mm-hmm.
Yeah.
Yeah.
That's what
it would help consumers, and it would also help entities, help businesses.
Yeah.
To have it.
And Angela's point.
Think of all the fun we'll lose if they do that, y'all.
That's we'll be out in the streets. But I think, Angela, your point about the question is excellent, and I don't think we really have time to go into it in detail, but watch what happens with the Supreme Court, because I would not be at all surprised if they say that the question presented was not, the issue was cert was improvidently granted on that question, because there's so many problems with it. It assumes things that counterfactuals and all sorts of things.
Which would be a two for Susky. That I don't think has happened before. Twice they've taken the case and twice improvidently granted. So I think we agree, to sum up, because our time is running short here. We have the Bissonnette case, which is going to look at the extent of that Section 1 exemption from arbitration. That is a potentially profound rule of law by the Supreme Court on the federal arbitration's limits in reach. I'm thinking we're agreeing here, to sum up, and we can go around the room. We can start Rick. I think on this case here on Coinbase versus Susky redo, that it's going to be a lot less profound and a lot less law going forward. Will it straighten out our questions about the delegation provision, or will it set us on a better path for drafting than we have been?
I'm hoping it will give us a better path for drafting. The problem of arbitration as a matter of consent is something that has been recited and then ignored. And where is the real consent in this? If parties say exclusive jurisdiction of a particular court, how much more do you need to say that then the delegation provision should have been extinguished? And maybe the court will give us some clarification on that, but I think there are vast ramifications to whatever they decide in this case.
Okay. All right. So maybe it's more significant than I thought. We'll see. Phil, and then Angela, you can have the last word. Phil, what do you think?
Yeah, I do think that it's going to be significant, because I don't think that if the court is actually going to hear this case, despite the bad question presented and all of that, then I see this, and again, this is just a guess, but I see it as an opportunity for them to really cut back on some of this case law and other lower courts that is really treats arbitration agreements as being cut above regular agreements. I think they really want to make clear that that's not. We've said it now 2 or 3 times. That is not the case, and here's a great example of why it is not the case.
Thanks, Professor Downs.
I absolutely think this is an opportunity for the court. With them hearing this case, I think is a boon. Not knowing obviously where they're going to go, but I really think that if they take advantage of this could really help to define delegation. It could really put some parameters about what arbitrators are doing, and it could really be something that could help businesses and consumers. And that's, obviously that's what we want. I mean, we're joking to say it would put us out of business, but the more that we have good information that's provided to companies and to consumers, that helps the overall marketplace, and it makes for a better economy down the line. So hopefully there'll be some things that come from this case that can be on the positive, that can really help the work that we do.
That's great. There's some real optimism here. Despite the fact that there is thought that this may be a bad question presented, there's some real optimism here. And this group's been pretty hard on some of the arbitration practices. And in summing up, Professor Downs, that's a good point for the consumers. It would be really nice to have a swift and efficient arbitration process to take care of questions about a sweepstakes. That would be a really ideal use of ADR, and it's a shame this had happened. A couple of points right below, there's some links here that you'll find to have some background on all these cases. I do want to add, and probably should have said it up front, we don't have argument dates yet as of this recording and as of the posting for either Bissonnette or the Coinbase case, but we will be back in 2024 when these cases are argued to let you know what we think of them. Thank you, panel, for joining. I really appreciate it. And keep up the good work.
Thank you.
Thanks so much.
Thank you.